All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Thank you very much. Mr. Hooper.
Yes, may it please, Your Honour. The matter. Yesterday.
Nous sommes en audience publique, Monsieur le Président.
Court officer, we are in public session, Mr. President.
Received a letter from the Ministry of Foreign Affairs and International Trade, a copy of which I provided, and can I ask be passed up to you, the judges. My friend Mr. Steinberg's seen it. I haven't shown it to Mr. Noetsek yet. Perhaps I can pass a copy over to him as well, so that he can see the nature of the document. Indeed, I've got copies as well for your Honour's colleagues. Perhaps I can ask that that be passed as well. You've seen it, haven't you? Naughty man.
Yes, Mr. Hooper, proceed.
The letter, save for one spelling mistake or word mistake, that you'll see, is plain on its face. So the position is this, that on the 19th and 20th, there is the third Africa-Arab Summit being held in Kuwait. I passed another document up to you, which is just something I took from the internet last night, which sets out, in fact, essentially what it is about. And you'll see in the first paragraph that there's to be an Arab-African summit in Kuwait in November, which include calls to bolster cooperation in the fields of politics, etc. It will also include further coordination of the Arab-African positions towards political issues of common interest, especially regional security and peace. And the Court, of course, will be aware that the African Union itself, which I think is composed of just over 40 African states, and the Arab League, which is composed of 22 Arab states, though some of whom are also members of the African Union, with the exception of Syria, which is presently suspended, are meeting, and it's the heads of state who are meeting, and that's on Tuesday and Wednesday of the week after next. So that is clearly in our submission, and the Chamber won't need reminding of the constitutional difficulties that then present themselves to the head of state, i.e. Uhuru Kenyatta, in respect of his attendance at such a meeting, in the absence of the Deputy President. So the Deputy President's presence is required on Kenyan soil in order to permit the President to go and attend this quite exceptional regional political summit of the heads of state of the African and Arab world. Such a meeting presents, we submit, and the need consequently on that for Mr. Ruto to be present in Kenya presents an exceptional circumstance, such as one would have thought comply even with my friend Mr. Sternberg's views of compliance with the criterion that were established in the Appeal Chamber's decision 1066. The question, if that is right, therefore, is there any alternative measure? As far as the prosecution are concerned, the alternative measure of not sitting at all until the 21st becomes attractive because it also helps them to the extent of having, they hope, one of the crime scene witnesses or both of the crime scene witnesses available to the chamber. But from what we've heard this morning, in respect of one of those witnesses, great uncertainties obviously subsist, and the position in respect of the second one is still also unclear. The position we submit would be that in order for the court to use its time effectively in these circumstances, it would seem sensible for the prosecution to consider calling Mr. Mopo and such other witnesses then becomes available in that order, and to be able to in fact be here on the 18th. That would be clearly a very effective, a more effective use of the court's time. In terms of this meeting, Mr. Ruto's presence in Kenya is compelling. If we don't sit, if that's the alternative suggested, and we don't sit until the Thursday, right at the end of that week, the risk is that we will then go on into December, and that will have, as has already been argued, and I don't repeat in detail, an adverse effect on the defence's preparations for the rest of this trial. It is our submission that the court should sit on the 18th, that the prosecution should provide a witness for that court, if it's the expert, so be it, and that in the circumstances, exceptional circumstances, in our submission, can be established through the circumstances relating to this important summit taking place and the consequence of that in terms of Mr. Ruto's position. I'd also...
I would expect the prosecutor to argue, I don't know the will, but that are you asking to have your cake and eat it too, in the sense that if Mr. Ruto has to be excused, wouldn't you make some sacrifices too, the defense, in terms of pushing the sitting date into December? Assuming, of course, that the interpretation and application of the Appeals Chamber's alternative measures criterion poses any difficulty.
Well, I'd submit that the Chamber was perhaps quite correct in approaching these issues, albeit that one touches upon the other, approaching these issues in a separate manner. First of all, the Chamber's decided to sit on the 18th. The prosecution is in a position to provide this Chamber with a witness on the 18th. Let's not lose sight also of the background to our sitting. We know that this is, we are sitting because of the consequence of what happened in respect of another case, and the need, of course, for this court to exercise expedition in respect of the current trial. But what has happened is that the defence are placed in a position that they didn't foresee and hadn't taken into account until, of course, that situation arose. And what the defence has hitherto argued, and repeats today, is that we have, I hope, demonstrated in every sense our cooperation to facilitate the wishes of the Chamber, as correctly we must do. But we've done that. And all this time that we're spending now, or in these further weeks, 2 weeks that have been set aside, are weeks that would be spent effectively in terms of necessary preparations in respect of important witnesses that are due to come in the not-so-distant future. I'm surprised to be standing here and finding myself addressing court dates in December, the 2nd and 3rd of December already. That period of time is not so distant for us. And it follows that, given also that we have a Christmas period to address and a New Year period to address, and as has already been said, a team that is necessarily going to be fragmented all over the world during that period, to come back then to, and we're not clear of the date, of course, when we will be sitting, but we anticipate about, I don't know, 10th or so of January, something like that. It really doesn't give us very long. So I'd say this, in a way we've made our sacrifices, and we ask the Chamber not to impose a further sacrifice on us. It's not a question of having our cake and eating it. It's a question of using the best time that the court can, taking all these factors into consideration. And taking all those factors into consideration, we've got a date, we've got a clear week. The week is the week of the 18th. The subsequent week is the 25th. We can do our witnesses in that time. And we have, against that, this extraordinary and exceptional event of the African Union and the Arab states meeting together. And we don't have to look far out of the windows of our lives to know what that implies in terms of the security of the area. I'm sure the court itself and Your Honours don't dispute for one moment the compelling need for the President of Kenya to be there and the consequent result that has on Mr. Ruto's whereabouts. So we fall back on this. If we're dealing, for example, with Mr. Mopo, the expert, does Mr. Ruto really need to be here in those circumstances? If we're dealing here with a crime scene witness, perhaps of a quality of witnesses we've seen so far, does Mr. Ruto really need to be here as opposed to fulfilling those obligations? So, taking it all in all, where is the balance? Your discretion, of course. Where is the balance? And the balance is we have a clear slot, those 2 weeks, and it gives us the opportunity then of moving from The Hague. This is the point. We're here, and people are here, and what we need is a time when we don't have to go and come back. We can go to Kenya, we can start again our investigations on a proper footing. We need to do that sooner rather than later, and we hope that if we start on the 18th...
Can you wrap up in 2 minutes?
Yes, certainly. We hope that if we start on the 18th, this team will be effectively investigating and preparing again, not by the 29th, but by perhaps the midpoint of that week. What we don't want is to risk losing the best part of another week at this time of year, because we've run into the first week of December. So, all in all, we'd submit, let's sit on the 18th. Here's quite an exceptional circumstance. The alternative is there, but it shouldn't be imposed on the defence. Not a cake and eat it situation, but rather rather a defence that has hitherto complied with all that the Chamber's asked, and asks really that the benefit of being able to stop the trial process in this sense sooner than later.
Thank you very much. Mr. Steinberg.
Thank you, Your Honour. Your Honour accurately predicted what my argument will be. Firstly, a couple of corrections perhaps. The Chamber did not decide to sit on the 18th. Your Honour has expressed
I thought didn't he say if?
my understanding was, well, if I'm wrong, the fact is Your Honours have not made that decision. So
no, we've not made the decision. I understood him. I took him to say if the Chamber decided to. But
yes. So the position was, as we left on the last occasion, that Your Honours asked the parties to agree on a 2-week period or a period sufficient to hear 2 witnesses, somewhere between the 18th of November and the 13th of December. My learned friend's preference was to start on the 18th, and for various reasons which I had indicated, my preference was to start on the 25th. I proposed as a compromise the 20th. For the reasons we've discussed in the previous argument, and mainly the availability of witnesses. So now, my learned friend wants to insist that despite the fact that he wishes his client to be excused for the first 3 days of the period 18th, 19th, and 20th, we should nevertheless start on the 18th with a witness that the prosecution does not want to call. And all for what? For the convenience of the defense team. Now, my learned friend has dressed it up in fancy clothing, but stripped down, it boils down to that. The convenience of one team must take preference over the convenience of the other party. And in doing so, also allow the accused to be excused, which will then be for, let me calculate, 5, 6, 7, 8, 9, 10 days out of the first 12 days since the appeal chamber has handed down its ruling that the accused may be excused in exceptional circumstances and that it should not be the rule.
The operative concept there is exceptional circumstances, not counting days and subtracting them from another number, isn't it? Exceptional circumstances.
Your Honours, the concepts are inextricably linked. And if I look at the first of the six considerations that the appeals chamber sets out, I'll quote from paragraph 62, the absence of the accused can only take place in exceptional circumstances and must not become the rule. And the only way to determine whether it's the rule or the exception is to look at the time period for which he's been excused and the time period for which he attends in my submission. And these things are cumulative. But leaving that aside,
was the appeal chamber not dealing with their criticism of the second part of the original Ruto relief granted by the trial chamber, where the trial chamber said yes, by majority, yes, there is discretion, and then secondly, the condition for the exercise of that discretion, which the appeal chamber criticized as essentially granting a carte blanche to the accused to stay away from the trial.
Your Honour,
isn't that what the appeals chamber was talking about there?
The appeals chamber was certainly dealing with its consideration of the correctness of the discretion as exercised by the chamber in its decision. But I submit that it cannot be boxed so narrowly as to avoid the plain meaning of the test which the appeals chamber has laid down. And taking it by way of analogy, if, for example, this trial were to sit for another 7 months, and of that time, at the end of the trial, we calculate that the accused was only here for a week, then would that not be the rule that he was excused rather than the exception? I submit that there's no escaping that logic. But, Your Honours, my submission is that we don't even need to get into that debate at this stage. I do not concede necessarily that the conditions themselves are exceptional. I've already argued that the ordinary duties of the President require him to travel, and this is not something which, in my view, would be exceptional, but we don't need to even get there. Because, in my respectful submission, my learned friend's application must fail on the second leg, which is the one we've been discussing. That is that of alternative measures. The prosecution has suggested the date of the 20th. it now appears that, that the accused will in fact be available from the 21st. We are arguing about 1 day. And in my submission, the clear solution to this is simply that we agree now that we start on the 21st, and the accused, the Chamber need not engage itself in this decision any further.
Can I just add one thing, and that is that my friend I may be astray, and my friend may be astray in saying I just wanted to say that if the summit takes place on the 19th and the 20th in Kuwait, and I would have thought that the President would remain in Kuwait for the night of the 20th, getting back to Kenya on the 21st, and unlikely to release the Deputy President for the night flight on the 20th. It's more likely he'd be making his way on the 21st. And I noticed last time, in fact, as I recall, that we expected Mr. Ruto to arrive during a day flight. Because he was able to, he got the night flight. So he's not someone who, you know, is not malingering, if I can put it like that at all. So, but it's very probable in those circumstances that if he's to come, he won't be here until the 22nd, if permitted to do so.
Mr. Steinberg, that's a new argument.
It is a new argument, and it's based only on supposition, Your Honours. There would appear to me to be, if the summit finishes on the 21st, I would be surprised, on the 20th, I would be very surprised if there weren't regular flights between a regional hub like Nairobi and, where was it? Kuwait. That would not allow the President to return on that date. Your Honours, I don't think it would be unreasonable to expect some degree of flexibility to allow Mr. Ruto to make it back here on the 20th.
Flexibility on the part of who?
On the part of himself and his colleague, Mr. Kenyatta.
Oh, not the part of the court.
Your Honour, I think the court has shown a remarkable degree of flexibility already, but there are limits. But of course, the other solution is we can start on the 22nd. That would be the fallback position.
All right, we will adjourn for 5 minutes and come back. Not so fast. I forgot Mr. Narratet thing. We got used to you being gracious and.
Thank you, and I don't get to speak much, but on these issues we have to make our submission. Thank you. Mr. President, Your Honours, we victims would again oppose Mr. Ruto's...
Mr. Narratet, let me make it simple for you. You support the prosecution's position, isn't that the case? On the excuse application?
Yes, we do, but we would also like to make one point quite clear on the perspective of victims.
Okay, make that one point.
Right, okay. As Your Honor requested, I would miss our submission on the 2 points that I have prepared, but just to save time, let me just go to the point. We are still in private session, no? Can I ask for a private session? Because this was the last point I was going to make.
A private session, then.
All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Nous sommes en audience publique, Monsieur le Président.
That officer, we are in open session, Your Honor.
Chamber issues its ruling. We will be brief. Our decision is that we will resume again on the 21st of November in hopes of completing the two witnesses to be called by the 29th. That's completing their testimonies by the 29th of November. And the two witnesses would be any two of the following witnesses: 469, 535, or the expert witness, Professor Mapo. As for the excusal request, the Chamber will grant the excusal for the 21st of November, and the reasons will follow. That completes our ruling on the matter.
As court pleases.
Right. We will now, our court officer is a witness on hand to be brought in. Yes, please, can you bring down the blinds and invite the witness back on the seat? Yes, that's why. If we can bring down the blinds and invite the witness in.
Nikifikiri kama hivyo ndivyo unavyouliza.
If I understood your question correctly, there were people who came to the showground after members of the population had taken refuge there at the showground. At that time, I was in Yamumbi. I was told that certain people had come to the showground and were taking down the statements of the victims. When I arrived there, I found that there were many people there. I approached one of these people and I gave them my statement. I cannot tell you who that person was, because they did not identify themselves. They simply took down notes about the testimonies, the statements being given to them, and then I returned to Yamumbi.
Did you show them the item you recovered from the burning houses in Yamumbi?
Nimekuambia hapana.
I have told you that I did not, and let me repeat, I did not give them that item.
When you spoke to the prosecution, one second, Mr. President, let me confer with my colleagues. Mr. President, may I ask that we go into a private session for 2 minutes?
Private session then.
Nous sommes en audience publique, Monsieur le Président.
We're in open session, Your Honour. The document KEN D0900250016 confidential will be given the number MFI T D09000092.
Thank you. Witness, we now have come to the end of your questions and the end of your testimony in court. The prosecutor has finished asking you questions, so has the lawyer for Mr. Ruto. The lawyers for Mr. Sang did not have any questions to ask you. Thank you very much for coming to assist us. We know you traveled from a long distance to come in order to help us to understand what happened in 2007. It is a difficult exercise for a lot of witnesses to come and sit and answer questions from lawyers. Sometimes questions that seem very obvious to the witnesses, and sometimes questions that are repetitive. But we appreciate the fact that you were able to come and sit through those questions until the end. Thank you very much, and good luck on your travel back. The blind will...
Thank you.
And the witness will be escorted from the courtroom.